right, good day. Welcome again. Employment Law Show. John Scholes here. Employment lawyer Lior Samfiru, co-founding partner Samfiru Tumarkin LLP, the most positively reviewed employment law firm in this country. I want to reach any time to get some information, get the compensation you are owed from what could be your former employee, but don't sit back in your laurels and just don't do anything about it. Reach out to Lior and his team and at least have a conversation, right? That phone number anytime you want to call, 1-855-821-5900. Email, which we'll probably get to a few of those today, is help@employmentlawyer.ca. But before all of that, there's a website that you should use. It will cost you nothing. In fact, it's anonymous and totally free, pocketemploymentlawyer.ca. There's all kinds of talking points and education on employment law that you learn on this show and our radio show every week, but you can read it for yourself at pocketemploymentlawyer.ca. And if you're ever curious about how much your severance might be, if it ever came down to the time that you were let go from your job, severance pay calculator rolled into that website as well, pocketemploymentlawyer.ca. But on the show today, rights for employees when ill or injured. That's coming up in just a bit. But Lior, we always start off with the week that was, a matter that you've been dealing with over the last few days. What's up, pal?
John, well, always great to be here and always kind of good to debrief about the week that I've had because it's been really busy, and over the past 6 months or so, a lot of questions coming in with respect to vaccines and being terminated because of that or being put on unpaid leave. So I've been dealing with a lot of those questions. By the way, if you ever have a question like that, you can reach out to my office. We'll talk about what your rights are. But the opportunity that I have here, that we have, is to educate the public about employment law, about workplace rights. We all have jobs. We all work, whether it's full-time, part-time, whether it's a senior role or a junior role. And the law is what protects us. The law is what gives us our rights and what imposes obligations on our employers. So we need to understand what those rights are. Without those rights, our work lives can be very difficult. It can be miserable. Many people don't know what their rights are. Well, if you're watching the show, by the end of it, you're going to learn a lot about your rights. You're going to learn a lot about what you can do if you're facing a workplace problem. And there's a whole history of our shows and TV shows and radio shows that we've done that you can delve into over the time to learn everything you need to know about your rights. And of course, if you want to have a private chat with me because something you heard about today really makes you want to ask more questions, we'll give you that contact information, phone numbers, and email addresses so that you can reach out to me and have that private chat. But of course, week that was, we said that's how we'll start, so that is how we're going to start. Let me tell you about a situation that crossed my desk over the past week. I spoke with a lady who had worked for 16 years part-time in an accounting role, and she was let go because the office that she was working was closing down. Kind of your average run-of-the-mill situation. I've dealt with thousands and thousands of them. So I asked her the question, well, okay, how much severance have they offered you? 16 years. She was a bit of an older lady as well. Said, well, they didn't offer me any severance. Well, that's strange. I said, well, why didn't they? I don't know. I thought maybe they went bankrupt or something. No. Well, because I'm an independent contractor. Said, well, I stopped her right there and I said, no, you are not. Let me make this very clear. It's impossible for anyone, to be an independent contractor when you've had a regular job for 16 years, even if it was a lot less than that. She was misclassified. She was called an independent contractor when she really was truly an employee. That's a very, very common situation. I've spoken with thousands of people in my 20 years of practice that have been misclassified, that have been treated or called an independent contractor, that believed that they were an independent contractor, even that they've paid taxes as an independent contractor, but they weren't. The law decides if you're an employee or a contractor. If you look like an employee and you act like an employee, you're an employee, regardless of what you call yourself. So for this lady, what does this mean? Well, because she was really an employee, not the independent contractor she and her employer thought that she was let go. She's owed right around 18 months, 18 months of pay. That's a lot of compensation that she's legally owed. Now, if she was truly an independent contractor, yeah, she probably wouldn't have been owed anything, but she's been misclassified. So I'm going to help her get that severance. It's not complicated. It's not going to take long, but I wanted to mention this today on the show to remind you, you are likely, if you believe you're an independent contractor, you're actually likely an employee. Unless you're in business for yourself and you have several clients and you decide how to schedule your hours and you pay for all your own expenses, unless that's you, you are an employee. You have then the rights of an employee: vacation pay, overtime pay, holiday pay, and of course, severance if you are let go. If you're not sure what applies to you, if you are truly an employee or not, certainly if you've been let go, we need to speak, so definitely give me a call.
And again, off the top of the show, you heard me mention pocketemploymentlawyer.ca. Here's a perfect example. Am I an employee or an independent contractor? That website will tell you. There's a tab for that one as well. So you can check it out, pocketemploymentlawyer.ca. It's interesting, though, because she may think, or she may have thought until she talked to you, okay, the company is right. You did mention the word bankruptcy there, but is there a difference if the company goes bankrupt, obviously they have no money, versus if they shut down? Most people think, well, they shut down, they can't pay me severance, they've just gone bye-bye.
Yeah, I agree, and I see that often.
Right.
Shutting down is not the same as bankruptcy. If you shut down, a company may still have assets. They may own equipment, they may own property, they may have accounts receivable for money coming in. So there's still the ability and the obligation to pay severance. But bankruptcy is a formal legal situation where the money that you have or that you own is a lot less than the debt that you owe to secured creditors. In that situation, an employee, unfortunately, is not likely to get severance, certainly not to get their full severance. But just because the company is shutting down, or even the company may be struggling financially, doesn't mean that that relieves them of their legal obligation to pay severance.
Does it make a difference if in the scenario where this former employee said, oh no, Lior, it's okay. They said I was an independent contractor. I agreed. We had a handshake that I'll just be an independent contractor. Does that change the legal framework at all?
It doesn't. The only one that can decide if you're an employee or an independent contractor is the law. The law makes that assessment. You can't circumvent that. You can't misclassify yourself. You can't decide to be something that you're not. And by the way, if you do that, you could have potentially problems with CRA. If you're not paying your taxes properly, if you're deducting things you're not supposed to deduct, that is a big deal. So it's always important to get that right. Again, if you're not sure what to do, maybe you've been offered a job, but it's an independent contractor, but you know you're really not. Before you accept that, let's have a chat. Let's talk about your options. Chances are you've been misclassified.
You know, it's funny, too, if you take a step back and think about it, if it were that easy that a company hires you as an independent contractor, don't have to worry about vacation pay, benefits, all that stuff, the whole world would be independent contractors. It would be better for every employee.
It does, and which is why the law says can't do that, because then everyone would do that. Whether you're working at a fast food restaurant, at a factory, at a car dealership, everyone would be an independent contractor. Clearly, that's not the case. The law is smarter than that. It's not enough to sign a piece of paper saying you're an independent contractor. You actually have to be an independent contractor, and in most cases, that's just not the case.
Radio show, where to find it? Well, on the radio, obviously, but employmentlawyer.ca is a good website to start. There's stations across the country that carry our 10-year-long radio show now, and we take a ton of phone calls on the show. People have questions, like I'm sure you do, and they call in and ask. We get not necessarily the good ones, but the interesting ones. We cherry-pick them and play them back on this show, which we'll do for the first time today, right now, Lior.
He's worked for like a major retailer as a senior manager for about 25 years now. A complaint was lodged, and there was an investigation regarding some customer complaints over a policy. It was over a return, by the way. As a manager, he has the right to refuse a return. And they came back and said, okay, we suspended you, and then investigated and came back and they fired him for cause. And what they gave him as a compensation is 16 weeks of a severance pay.
So let's start addressing this call by talking about termination for cause. So this person got in trouble with his employer because of a customer return that he approved or didn't approve. So obviously I don't know enough about the case to say whether he did something wrong. But what I do know is to say that even if he did do something wrong, let's look at it from the employer's best case scenario. The employee did something wrong. They didn't follow policy. That does not mean that he can be let go for cause. It is extremely difficult to terminate employment for cause. It's not enough for the company to show that the employee did something wrong. The employee would have had to do something terrible, something so bad that it makes it impossible to continue employing them. Then and only then can the company consider a termination for cause. That's just not it. Because it's not a termination for cause, he is owed severance. Now, we know he was offered 16 weeks' pay. That's not a lot. Let's find out how much he's actually owed. Let's take this information and let's go to our severance calculator, which you can find at pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. When you go there, you can use our severance calculator. Let's do that right now for this 25-year employee that was let go. We know then he's been there for 25 years. He's been offered 16 weeks pay. We go through the analysis. We see at the bottom row there that he, in fact, is owed 24 months pay, 2 years pay. So if we say 16 weeks is 4 months roughly, he's owed 24 months. That's another 20 months pay that he is owed. It's not cause. He's owed that severance. Same with you. If you've been let go for cause or without cause, before you even look at your severance letter to see what they've offered, understand what you're actually owed. Go to pocketemploymentlawyer.ca or call me, but make sure that you never ever accept anything less than what you're fully owed.
Going to throw one more website at you, terminationquestions.com. It is exactly that, a place for you to ask your questions. Lior's team gets through them, and they give you a response, so feel free to use that anytime, terminationquestions.com. Here comes one for this show. Lior Chantel writes in, says, I've been put on a layoff without a specific return date. I'm the only one at the company without work right now, and this happened just a few days after I confronted my manager about the many hours I work overtime without extra pay. When do they have to call me back by?
So I get variations of this question very often. I've been put on a layoff. How long can I be on a layoff? So let's be clear. Unless you're part of a union, your employer does not have a right to put you on a layoff. So for Chantel, she could have treated that layoff as a termination right away. She does not have to sit at home and wait and hope that she's going to be called back. She can treat it as a termination and require her employer to pay severance. By the way, many people have been on layoff now, still as we speak, for months and months, if not years, because of COVID-19. If you are still on a layoff and you haven't been called back to work, you have the right now to treat that as a termination. You can say enough is enough. There's no deadline. You don't have to wait. You don't have to see what the employer does. You can make that decision. Now, in this particular situation, what's also interesting is that this layoff happened after she inquired about overtime. If she's put on the layoff as a punishment for having the audacity to ask for overtime, that's illegal. We call this a reprisal. She's being punished for asking questions about her rights or trying to pursue her rights. You cannot be punished for pursuing your rights, whether it's overtime, vacation pay, whether it's a situation that someone's harassing and mistreating you and you're asking for the employer to intervene. You cannot be punished. If you are, there's going to be significant consequences. So yeah, this employer for Chantel did everything wrong, and Chantel needs to connect with me as soon as possible.
And the whole not getting paid for overtime is yet another layer on top of this you're going to have to deal with, right?
Absolutely.
You work it, you got to get paid for it.
If you work the overtime, you have to get paid the overtime, even, by the way, if it's not approved.
Rights for ill or injured employees. We're going to get to that, but short break first. So the number as we go into that break, 1-855-821-5900. Email help@employmentlawyer.ca. It's the Employment Law Show, coming right back. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, thanks for hanging in. Welcome back, Employment Law Show. John Scholes here and Lior Samfiru, co-founding partners, Samfiru, Tumarkin, LLP, the most positively reviewed employment law firm across this country. I want to talk about the topic for today, and that is rights for employees when they are ill or injured. Let's get into it. Number one, Lior, you cannot be fired. You can't be fired because of your illness or an injury.
You cannot at all. That's very important to remember, that if you're sick, you can be off work, you can take the time that you need, and you cannot be let go because of that injury. You cannot be let go because the company says, well, it's going to be a bit of a pain if you're going to be off for a while. No, you have rights to keep your job. You still are an employee in that situation. You simply are an employee on leave. And the employer may not agree. They may feel in their minds that you're not necessarily sick. Well, it's not for them to say. It's for your doctor to say. As long as your doctor backs you up, you cannot be mistreated, punished, threatened, fired, whether you take a day off, a week, or a year. So no. Most important thing to remember is you are able to take a leave of absence, a medical leave of absence, with your doctor's support without being punished in any way.
Point number 2 is this: if you are let go because of a medical situation, an employment lawyer can determine the correct compensation. Don't be mystified by anything in that regard, right?
So yeah, certainly if you are let go in that situation, there's a few things. Number one, we know severance, right? We've been talking about severance. Severance is going to be owed probably a heck of a lot more than what you've been offered. That's number one. Number two is there could be human rights damages here because if your employer is letting you go when there shouldn't be, because you're sick, because you're ill, then yes, you're actually going to be owed additional damages as well. Those need to be assessed. And finally, if you're still sick and you're let go, that means it's arguably going to take you longer to find another job because you're not able to work the way you were pre-sickness or pre-injury. That means even more severance is going to be owed to you than the usual circumstances. So if you are let go, anything to do with the sickness, anything to do with an injury, we have to talk because your entitlements are going to be that much more than they usually will be.
We're going to go back to number 1 because I skipped ahead a couple, but the first one should have been the first one's now the third one if you've done the math. An employee can take a medical leave or rely on their disability benefits through work if they are unable to work, right?
Yeah, so I alluded to that before.
Yep.
Here's where we talk about the doctor. The doctor is judge and jury when it comes to your ability to be off work. If you have a doctor's note saying you cannot work, whether it's because of stress-related issues or for any other reason, it doesn't matter. If the doctor says you cannot work, you can be off work. That means you can also access any sick days that are available to your employer. If the employer has a short-term disability plan or a long-term disability plan, you can access those as well. But it all starts and ends with your doctor. So you need to have that doctor's note. And your employer can ask for it. Your employer can insist that you not take off work until you get that doctor's note. So it doesn't matter what you, the employee, says or what the employer says. It's that doctor's note, which, by the way, cannot be questioned by your employer.
They're the gatekeeper of your health as it comes to your workplace. Right?
They're the gatekeeper. They're the only one whose opinion really matters when it comes to your health.
And the next point, I love this one. We always get calls about this on the radio show. Your employer is allowed to know your prognosis, but not the diagnosis of your condition, right?
Absolutely. What does that mean? That means your employer is allowed to know if you can work. Your employer is allowed to know how long you're going to be unable to work or off work. Your employer is also allowed to know what type of accommodation do you need. Those are legitimate questions. We put them under the heading of prognosis. But when it comes to diagnosis, that's something your employer is not allowed to ask or to demand. So they're not allowed to know what is the medical condition, what treatment you're getting, what medication you're taking, or what specialist you're seeing. That is irrelevant, and that's personal, private information. And by the way, I see that now often with vaccine exemptions. Your doctor may feel that you shouldn't be getting the vaccine because of medical reasons. That's for your doctor to decide. All your doctor has to do is give you a doctor's note saying you cannot get it for medical reasons. Your employer is not allowed to ask, well, what are the medical reasons? We need for the doctor to tell us what is the condition. That's for you and your doctor to know, and your employer doesn't have a right to know that. So prognosis, yes. Diagnosis, no.
Again, we're going through a short list of rights for employees when it comes to being ill or injured, and this one, we'll wrap it up with this. You mentioned the word accommodation. If you need accommodation in the workplace, your employer must provide it.
So it's not always black or white. It's not always a situation where you can work or you cannot work. Sometimes there's these things in between. Well, yeah, I can work, but I need some help. I can't do my old job exactly, or I need part-time hours, or I need modified duties. We call this accommodation. So if you have a medical issue and your doctor says you need accommodation, your employer has the obligation, and it's a very strict obligation, to find that accommodation, to make it happen, to give you those modified duties or modified hours. Even if it's difficult, even if it's not something that the employer can do easily, they still have to do it. Now, of course, there's going to be a point beyond which the company doesn't have to go where it's too difficult to provide accommodation. But oftentimes, I've seen many times where a company just doesn't want to try hard enough. And that's a human rights violation. We call that a failure to accommodate. So if you're in need of accommodation, make sure you get specific information from your doctor. What kind of accommodation for how long? And give that to your employer. If your employer won't accommodate you, won't talk to you, won't even try to make it happen, you know you potentially have a human rights violation on your hands, you have to call me. Accommodation is a very important feature of our rights as an employee.
Does that threshold for the employer as to how far they have to go for accommodation, does that change whether it's a little mom and pop shop or a big multinational company with resources and tens of thousands of employees?
I think practically it does, because arguably a company, as you said, 10,000 employees, many roles, a lot of resources, it's going to be arguably easier for them to find another role. There's going to be more flexibility that they have, whereas if you work for a company where you're the only employee, that employer may not have the ability to give you another job because there's no other job. So yes, certainly the bigger the company, the more resources and positions they have available, the harder it's going to be for them to say, oh gosh, that's just too hard.
Again, any other questions or any of this rings familiar with somebody you know, possibly yourself, just reach out and have a phone call, 1-855-821-5900. And employmentlawyer.ca, the firm website, that is where you go to find a radio show in your community where you can catch our radio show. We'll get to our second call of the day from our radio shows now.
With my company, I've accumulated about 9-10 weeks of vacation time. If I were to get laid off or fired, number one, do I have to get paid out? And also, I'm in commission-based sales, and I have about $1 million in confirmed orders over the next year or so. How long do I get paid my commission?
It's a great question.
It's a great question. So let's start with vacation.
Yep.
Obviously, any accrued vacation that you have to get paid out if you are let go or if you leave, whether it's 2 days vacation or in this case, 10 weeks. That's a lot of accrued vacation. If you have that accrued, the company has to pay it out. There's no choice. They have to pay it out. Now, where it gets even more interesting is with respect to any commissions or bonuses that are outstanding. The general rule is this. If you've done whatever you need to do in order to earn the bonus or to earn the commission, it just hasn't been paid yet, then the company has to pay it to you when you leave or when it would have otherwise come due. As long as you did what you were supposed to. If because you're leaving you still have to do a few things that you're not going to get a chance to do, then arguably that doesn't get paid. But if you've done your role, what you needed to do to earn that commission is done, it's over. Now it's just a timing issue, then that commission will still have to get paid to you. If your company won't pay that commission, if you're leaving or let go and you're not getting the commissions that's outstanding, the bonuses that are outstanding, we need to speak. The law is quite in favor of the employee in that regard. There's some very important and very recent court decisions that help that the employee in those cases. So definitely worth picking up the phone and having that chat.
We'll get to another phone call from the radio show, but first, got to take a short break, so we'll do that in between. 1-855-821-5900 to reach Lior and his team anytime, and employmentlawyer.ca and pocketemploymentlawyer.ca. Don't forget that website. We'll continue Employment Law Show in just a moment. People think you should go to the government to get severance pay. Employmentlawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at employmentlawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. Employmentlawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. All right, welcome back. Employment Law Show. A few minutes to go. I mentioned another phone call from our radio show, employmentlawyer.ca. That's the website you want to go. There's a media tab, and you'll find a station near you that carries it. And have a listen. Maybe call in sometime with some questions. Phone call number 3 is right now.
I've got a situation with my employer. Been with the company doing the same thing for 29 years, and a group bought our company and have of recent decided that they think they need to cut my income. And I've said to them, you know, I play ball with them to a certain extent. I get a salary and commission, and they want to cut out the salary completely, but not increase the commission, but trying to cut benefits as well. So I'm trying to figure out what to do about it.
So I think and I hope that our regular viewers will know what I'm about to say. And that is, whenever we're starting to look at changes to compensation, changes to the terms of employment, this term constructive dismissal must come to mind. So what's happening here is they're not necessarily saying we're reducing your pay, we're changing your compensation structure. You used to have commissions and salary, we're now removing the salary portion. That is a constructive dismissal any day of the week. His employer does not have a right to do that. They don't have a right to restructure his compensation, take a part of it out, etc. What does that mean? That means that now he can make a choice. He can, of course, accept this change and continue working. Of course, it's his decision. Or he can choose to treat that as a termination. By taking away my salary, by making me 100% commission, it's as if you've terminated my employment. Now you must pay me severance. And by the way, John, after 29 years, he's going to be owed a significant amount of severance. So let's talk about that. Let's go to pocketemploymentlawyer.ca and let's use our severance calculator tool to calculate exactly how much severance he's going to be owed in this situation. So we know he's been there for 29 years. He's a bit older because he's been there for that long. He's in a sales role. And the company's not terminating him at all. They're saying, we're just changing your compensation. We're not terminating. But despite the fact that the company is not terminating his employment, you see at the bottom of the screen, he's owed 24 months' pay if he chooses to treat this as a termination, as a constructive dismissal. 24 months' pay. That's a significant amount of compensation. Well, same with you. If you're facing changes to terms of employment, one of the the decisions you have to make is, do you treat this as a termination and require the company to pay severance? Before you say yes or no to the company, we really, really should talk.
If he really, really loves his job, he doesn't want to leave, even though that 2 years pay is pretty attractive at that age. Can he take it out for a spin in writing, say, I'll try it, but if it falls apart, I'm not doing it?
He can do that for a short period of time. He can tell me, I'm going to try this for the next little while. And as long as it's a short period of time, a few weeks, maybe a couple of months at most, then he can do that without it being considered an acceptance. But again, he has to tell him, that's what I'm doing. I'm not accepting this. I'm just going to try and see how it works. And then after he tries it, if he's still not happy, he would still be able to say, that's a constructive dismissal.
We'll get to this quickly as we wrap up your terminationquestions.com. Min says, what should somebody do if they disagree with a performance review and are worried that their boss is slowly working to get them out the door?
Well, first of all, if that's what you think is happening, that's probably what's happening, okay? And I've seen many times where a performance review or being put on a performance improvement plan is a precursor for a termination for cause. It's part of what the company is doing to try to build a case to let the employee go for cause. So what do? You got a negative performance review, you got a performance improvement plan, you don't agree with it, you don't think it's legitimate, or maybe it's in bad faith. Well, you have to say so and say so in writing. Send an email to the company outlining why you disagree with it, what's inaccurate there, what they haven't considered. Of course, you can still and must still be professional and be courteous. I'm not suggesting you go and be aggressive and accuse people of things necessarily. But you have to put your position known in writing. By doing that, you're going to make it that much harder for the company to rely on that, to let you go at some point for cause. Remember, silence is the same as acceptance. So if you get a bad performance and you don't say anything, you may as well have said, I agree with this. And if you agree with it, it will be held against you at some point. That email is important. You don't even need a response from the company. Just by sending that email, outlining why you disagree with it, you've protected yourself. You're going to make it easier for the company, or harder for the company, I should say, to let you go.
In most cases, you just trust your spidey sense, right? Like you just got a feeling something's going.
If you think something is being built against you, then the writing is on the wall. It probably is.
That'll be it for this show. Thank you so much for all your correspondence through email and otherwise. You want to send one, help@employmentlawyer.ca, 1-855-821-5900. And finally, pocketemploymentlawyer.ca. We'll catch you next time. Employment Law Show. People think you are only owed 2 weeks' pay when you lose your job. Employmentlawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at employmentlawyer.ca.